There is one blank line on your bank account paperwork? Just one? And if it's still empty right now, it could quietly cost the people you love thousands of dollars, money you already earned, already saved, already set aside for them. Here's the part that stops most people cold. Recent surveys suggest that roughly 3 out of 4 American adults don't have even a basic will in place. 3 out of 4. And most of them have no idea that a will alone would not have protected this account anyway. Stay with me for the next few minutes, because I'm going to show you the single 10-minute fix that closes this gap, and it won't cost you $1. Because here at Retirement or TV, I believe the same thing every single day. The people who work the hardest for their money should never be the ones who lose it to a mistake nobody warned them about. And today, I'm going to make sure nobody warns you too late. Before we even start, do me one small favor. Tell me in the comments where you're watching from, just your state. Say Texas, Florida, Ohio, wherever you are. I ask because this one rule works a little differently depending on your state. And I read every single comment to see where my seniors are tuning in from. So go ahead, drop your state below, and then let's protect your money. Now, one honest note before we go further. I'm not an attorney, and I'm not a financial advisor. Nothing in this video is personalized, legal, or financial advice. This is general educational information to help you ask better questions and know what to look for. Rules also vary from state to state, so for your own situation, please confirm the details with your bank or a qualified professional you trust. Fair enough? Good, let's get into it. So what is this mysterious blank line? On most bank accounts, your checking, your savings, your CDs, your money market account, there is a field called the beneficiary, or sometimes payable-on-death, often shortened to POD. Think of it as a simple instruction to your bank. It says, when I pass away, hand the money in this account directly to this person. That's it. It's a contract between you and the bank. You name someone on that line, and the bank agrees to give them the money when you're gone. And here's the single most important sentence in this entire video, so let me say it slowly. That little beneficiary line beats your will. It doesn't matter what your will says. It doesn't matter how carefully you wrote it or how much you paid the lawyer. For that specific bank account, the name on the payable-on-death line is what controls the money. Your will has zero power over it. Now be honest with me, and no one's judging here. Before this video, did you actually know that the beneficiary line beats your will? If you had no idea, type the number 1 in the comments. If you already knew, type the number 2. I'm genuinely curious how many of us were never told, because I have a feeling the 1 South are going to far outnumber the 2 South. And that tells you everything about why this matters. Let that sink in for a second. You could have a beautiful, expensive will sitting in a drawer. If this one line on your bank account is blank or has the wrong name on it, your will can't fix it. So what actually happens if you leave that line empty? The account doesn't just magically go to your kids. Instead, it usually has to pass through a court process called probate. And probate is where the quiet costs come in, according to widely cited estimates. Probate commonly costs somewhere between 3 and 7% of an estate's value, and it can run higher when things get complicated. On a $500,000 estate, that's often somewhere in the range of $15,000 to $35,000 gone to attorney fees, executor fees, court filing fees, and other costs. That's real money. Money you meant for your grandkids' education, or your spouse's comfort, or just to make life a little easier for the people you're leaving behind. Instead, a big slice of it can go to the process itself. And then there's time. By some industry estimates, probate can take well over a year, sometimes around 16 months on average, before your family sees a single dollar. Imagine that. Your spouse or your children already grieving, now waiting more than a year and watching thousands of dollars disappear in fees, all because one line was left blank. And I want you to understand why this happens, because once you see it, you can't unsee it. Probate isn't a punishment. It's just the court's way of officially deciding who gets what when there's no clear instruction on the account itself. But official comes at a price. There are filing fees that vary widely, in some states just a few dozen dollars, in others $400 or more, just to open the case. There can be executor fees, appraisal costs, and, most of all, attorney fees, which are often the single biggest expense. In a handful of states, those attorney fees are even set by law as a percentage of the entire estate, not the profit, not what's left over, but the whole gross value. So the bigger the estate, the bigger the bill, whether the work was complicated or not. And here's something else most people never consider. Probate is usually a public process. That means the details of what you owned and who received it can become part of the public record open for anyone, including distant relatives or even strangers, to look up. For a lot of people, that loss of privacy alone is reason enough to keep an account out of probate. A payable-on-death beneficiary keeps that transfer private and direct just between your beneficiary and the bank. Let me make this real with an example. And I want to be completely upfront with you. This is an illustrative story, a composite I'm using to show how this plays out. It's not a specific real person. I'll call her Margaret. Margaret was 72. Careful her whole life. She had a will, she'd done the responsible thing. She had about $47,000 in a savings account she'd built up over decades, and in her mind, that money was for her daughter. Simple. But Margaret never filled in the beneficiary line on that savings account. She figured the will covered everything. When she passed, her daughter went to the bank, certain the money would be there for her. Instead, she was told the account had to go through probate because there was no payable-on-death beneficiary named. 14 months. That's how long it took in this example before her daughter could touch the money. And by the time the attorney fees and court costs were paid, a meaningful chunk of that $47,000 was simply gone. The heartbreaking part? It would have taken Margaret about 10 minutes and one signature to prevent all of it. One line? That's the whole difference. And I have to ask, because so many of you have lived, this has something like Margaret's story ever happened in your own family? A frozen account? A long wait? Money lost to fees? If it has, share it in the comments. I know it's not easy to talk about, but your story might be the exact push someone else needs to go fix their own account tonight. This community looks out for each other. That's the whole point. Okay, enough about the problem. Here's the good news, and it's genuinely good news. Fixing this is simple. It's usually free, and you can start today. Here's exactly how. Step 1. Call your bank or credit union, or go online and ask this exact question. I'd like to add a payable-on-death beneficiary to my account. Can you send me the form? That's the magic phrase, payable-on-death beneficiary. Some banks call it a POD form. Some call it a beneficiary designation. And in a few places, it's even referred to as a Totten trust. They'll know what you mean. Step 2. Fill in the person you want to receive the money. You'll usually need their full legal name, and often their social security number, date of birth, and address. So have that information ready before you call. It makes the whole thing faster. Step 3. Return the completed form to the bank, and this is important. Ask them to confirm in writing that the beneficiary is now on file. Don't just assume it went through. Get the confirmation. And that's it. No lawyer required. There's no court. When that day eventually comes, your beneficiary simply brings a copy of the death certificate and their ID to the bank, and the money is released directly to them, bypassing probate entirely. No 16-month wait. No thousands in fees. The money goes where you wanted it to go. Now, because I promised you honest information and not just a feel-good tip, let me give you a few things the quick advice online usually skips. First, keep it updated. Life changes. People pass away, relationships change, families grow. Here's a trap most people never hear about. At many banks, if your named beneficiary passes away before you do, and you never update the form, the money can end up right back in probate, the very thing you were trying to avoid. So review that beneficiary line every year or so. Put it on the same schedule as something you already do. Say, every birthday. Second, a payable-on-death designation does not shield the money from legitimate debts or taxes. The funds can still be used to pay what you genuinely owe, and depending on your situation, they may still count as part of your taxable estate. For most families, this isn't an issue, but I'd rather you hear it from me than be surprised. Third, this covers bank accounts. For investment accounts like an IRA, a 401k, or a brokerage account, there's a very similar tool, usually called a transfer-on-death, or TOD designation, plus the account's own beneficiary forms. Same idea, slightly different name. So while you're at it, check those too. And fourth, and I'll keep saying this because it matters, a POD designation is a powerful tool, but it's not a full estate plan on its own. For larger or more complicated situations, a proper trust and a conversation with an estate attorney is still worth it. Think of this as the simple, free first move that protects your everyday accounts today, not the finish line. Before we wrap up, let me flag one more thing, because well-meaning people get this wrong all the time. Some folks think the easy solution is to just add their adult child as a joint owner on the account instead, and I understand the appeal, it feels simpler. But that can open up a whole different set of problems. As a joint owner, that person may have full access to your money while you're still alive, and the account could even be exposed if they run into debts, a lawsuit, or a divorce. A payable-in-death beneficiary is usually the cleaner tool, because the person you name has no access at all while you're alive. None and only receives the money after you're gone. You stay in complete control the entire time. You can spend it, move it, or change the beneficiary whenever you like. It's a beneficiary line, not joint owner in most cases. That's a distinction that can save your family a lot of grief. You might be wondering if this is so simple and so important. Why has no one ever told me? It's a fair question. And the honest answer is that no one is really responsible for telling you. When you open a bank account, the person helping you is usually focused on getting the account set up, the deposit, the debit card, the online login. The beneficiary line is often just one more optional field on a long form. And if you don't ask about it, it frequently gets skipped. The bank isn't hiding it from you exactly, but they're also not going to chase you down years later to remind you it's blank. It's not their job to plan your estate. It's not the government's job either, which means it quietly falls to you, and now that you know you're already ahead of most people, it's really the whole theme here. The most expensive mistakes in retirement are rarely the dramatic ones. They're the quiet ones. The blank line. The form nobody mentioned. The 10-minute task that keeps getting pushed to someday. And someday, unfortunately, has a way of arriving without warning. Let's bring it home. 3 things to remember. 1. That little beneficiary, or payable-on-death line on your bank account, beats your will. If it's blank, your account may be headed for probate no matter what your will says. To probate can cost real money, commonly a few % of the estate, and sometimes far more, and it can take well over a year. And 3, the fix is free and takes about 10 minutes. Call your bank, ask for the payable-on-death beneficiary form, fill it in, and get written confirmation. Then review it once a year. Here's what I'd love for you to do this week. Take 10 minutes, just 10, and check that beneficiary line on your own accounts. It may already be filled in, and if so, wonderful. You'll have peace of mind. But if it's blank, you now know exactly what to do about it. And I'm genuinely curious, did you already know that the beneficiary line beats your will? Type yes or no in the comments. It honestly helps me understand what to cover next, and it might nudge someone else to go check their own accounts. If this was helpful, do one kind thing today. Share it with someone over 60 who needs to hear it. Might just save their family thousands. Take good care of yourself, and take care of that one blank line. Your family will feel the difference for years to come. Because at Retirement or TV, we don't just plan for retirement, we protect it. I'll see you in the next one.